review working of the Constitution chaired by Justice Venkatachalaya. Even prior to the Law Commission report, there was a national convention organized in Delhi in 1993, soon after the demolition of Hon'ble Mr. There was a great concern about this communalism in politics and the kind of damage it was causing to the nation. At that time, many people participated, several retired judges, professors of law, vice chancellors, medical personnel, and very eminent people participated in that. That, at the end of it, they constituted a committee to suggest electoral reforms. And that committee also was headed by Ms. V.R. Krishnaya, and my friend Mr. Sorabjee and I made active part in that. We are organizing the convention also in the committee. That committee made certain recommendations. Now, I would like to mention a few of them. One is they said at least 35% of the votes should be polled in a constituency out of the total number of electorate. At least 35% should go to the polls to exercise franchise. Otherwise, there should be re-election. There are instances where only 10% or 12% they participated in the election, others did not during the terrorism, high terrorism in Punjab. And then still, one person who got more votes is elected, he represents the entire constituency. So this recommendation was made. Second recommendation was to contain this communalism and casteism in politics, and also to enable political parties to form into groups and combinations to contest. We suggested that a candidate to be declared elected from the constituency shall secure at least 50% of the votes polled in the constituency. Without that, there should be a re-election limited to the two leading candidates. We thought that way it will be possible to contain communalism, because no single candidate can secure 50% votes on the basis of communal card or caste identity. So that was the suggestion. In fact, Mr. Prashant Kumar, former Vice President, he spent a lot of time devoting his attention to electoral reforms. He suggested two things. One is this. Another thing he suggested was right to reject all the candidates. If majority of the votes polled indicate that all the candidates contesting are not acceptable, there shall be a fresh election. Now, Anna also is asking for it. The Election Commission is initially opposed this suggestion, but now Mr. Qureshi, as announced the other day, when we were together in one discussion, he said that the Election Commission is having a rethinking on the issue. They are also inclined to have it. This is one way of trying to ensure that only acceptable candidates they enter the arena. One more recommendation made by the Commission was there must be a law to regulate political parties, to ensure inner party democracy. Every party maintains regular accounts and funds, and donations received and expenses incurred by parties, and accounts shall be audited regularly. Then there shall be a commissioner to decide whether a political party is promoting communalism or acting against the provisions of the Constitution, etc. Then that commission shall be appointed by the Prime Minister and the head of the opposition jointly, and one person nominated with Chief Justice. These are our suggestions at that time. Law Commission has made elaborate recommendations. They are not implemented. In 2002, the National Commission to Review the Constitution, they made certain very pertinent observations. They said the main cause and source of political decay is the ineptness of the electoral process, which has not been able to keep out criminals and anti-social and undesirable elements from participating in and even demonstrating the political scene, even dominating the political scene and polluting the electoral and parliamentary process. Next, they said democracy cannot be said to be an inclusive representative democracy. The pluralism and diversity of India is not reflected in and captured by the democratic institutions. Then said, like participation of women in public affairs and decision-making process is nowhere near proportionate to their numbers. The enormity of the cost of election and electoral corruption have been a grievous deleterious effect on national progress and has led to the degradation of political parties to the detriment of common good. Money power and criminal elements have contributed to pervasive degradation of standards in public life and have criminalized politics. There are no legal instrumentalities or set of laws regulating the conduct of political parties. Legitimacy of fundraising, audit, and account requirements in the party democracy. I would like to place a thought before you. Fortunately, we have ministers. Talk about eminent president who has contributed a lot to the growth of public interest litigation in this area of public administration, but also two former Attorney Generals here and one more than one term, and among other leaders of the bar we have here. I would like to place a suggestion for consideration. Under the Commissions of Inquiry Act, when the government constitutes a commission to go into certain aspects and make recommendations, is it not a power coupled with a duty? Is not government under legal duty to consider the recommendations, consult other persons involved in the decision-making process in Parliament, and then take a decision on every recommendation? If that is not done, is it not possible to maintain a public interest litigation only for the limited purpose of ensuring that every recommendation made by a commission, government commissions, law commission made so many recommendations, but how many are really looked into and acted upon, considered and acted upon? So I was just placing an idea for consideration. If the leaders of the bar think it is possible to move in that direction, then it may be possible through the judiciary, through a PIL, to compel the government to pass recommendations, and in the PIL we may also include as parties the leaders of legislative parties in Parliament who have to act, assist the court in this matter. This matter of national concern. Question of survival of the constitution is involved, future of democracy is involved, rule of law is involved, human rights are involved, everything of value is involved. Without that, I do not think our pious hope that Parliament would consider our recommendations, our suggestions, and act and legislate will at all bear fruit, considering the composition of Parliament as it is today. Now, some of the suggestions which I want to make are these for your consideration. The Supreme Court declared in the Indian National Congress case versus Institute of Social Welfare in 2002, there is a provision for registration of political parties in the Election Commission has to register them. Then they get recognition as a recognized political party, a national party or state party. That's a subsequent classification. But court held, election has power to register, but it has no power to deregister or cancel the registration except on the ground of fraud. To my mind, they said Section 21 General Clause Act, which says power to do a thing includes power to cancel, rescind the earlier decision, doesn't apply because this is quasi-judicial power. No use quarreling with the correctness of the decision. I have my own views to the contrary. But if you have to move forward, it is necessary to empower the Election Commission with this power to cancel the registration of political party if it acts contrary to the commitment made to the Election Commission at the river registration. Every party is required to swear by the Constitution that will bear true faith and allegiance to the Constitution and the ideals which are mentioned there, democracy, secularism, etc. If any party is deviating from this and engaging in communal politics, etc., the Commission should have power to cancel the registration. Next, I would like to place another suggestion, that is concerning the right of the voters to know the antecedents of candidates contesting. In the Association for Democratic Reforms case, the Supreme Court declared this right as part of the right to freedom of speech and expression of all citizens. Subsequently, what happened? All the political parties got together, unanimously resolved to set at naught the judgment. So how can we allow our candidates to disclose their antecedents to the people? What will happen? No, this judgment should go. Then they passed an ordinance because of the India government, followed by an act. Ordinance Act was challenged, and the matter came before a bench of three honorable judges, Justice Shaw, MB Shaw, this is Dharmadkari, and this is PB Reddy, who is with us happily today. And they struck down that ordinance and the act, saying it's contrary to Article 19(1)(a). The right which you have declared flows from the Constitution. From Article 19(1)(a) of the Constitution is right to freedom of speech and expression. How can the legislature take it away? It can't happen. Then they directed that the Election Commission shall operationalize this right by issuing necessary orders under Article 324. With the hope that the Election Commission will give necessary instructions to all returning officers and candidates that they must file these declarations on oath, an affidavit, and then in course of time, whenever the election is challenged on this ground of making a false declaration, the courts would go into it, election courts, and they will take action. Unfortunately, recently, 2 decisions have been given. One by the Kerala High Court. Kerala High Court said, no doubt, non-compliance with a provision of the Constitution or a statute or a rule or order is certainly a ground for invalidating the election. But they said, but then this is not a provision of the Constitution, Article 324. Order issued under Article 324, if it is violated, it doesn't mean violation of Article 324. Therefore, the election cannot be set aside. In another case, a member of parliament suppressed assets of his separated wife and his children through her children. He did not include it in the assets. That was pointed out and made a ground of attack. The Supreme Court said there is no pleading and proof that this suppression has materially affected the result. Once again, as I said, no use quarreling about the decisions which are there already, but how to make this right effective? It is only possible through legislation which needs to be done. Then, there are one or the other small things I wanted to mention before concluding. That is, his right to recall candidates. I have already covered about it. The country has too many political parties and too many independent candidates. Look at the list of candidates in some constituencies, 200, 300. Do we need them? Is it desirable to have them? There must be some mechanism to control this. If the 50% one vote requirement is made a law, then many political parties have to join hands together in order to secure 50% in one vote for their candidates while they do it. That's one way of polarizing the political parties. And second thing is independence. You remember at one time, even for presidential election, when a member of the bar used to regularly contest. And the requirement of filing a nomination was so easy. Then the court found, the legislature, parliament found, this should not be the position. Any person can come and contest an election. He made it stringent provisions are made. Now it's not possible for anyone and everyone to come and file a nomination for contesting presidential election or vice presidential election. So for independence to contain them, I think there should be some provision to put some breakers, some break on their way by increasing the security deposit amount or something like that to contain them. They unnecessarily they play the spoil sport. Yet another sanction which I have in mind is there is a classification of national parties and political state parties by the Election Commission. Under the symbols order, they make this classification. But the norms are so diluted that even a party which has presence only in 2 states or 3 states in the country is considered a national party. The word national must have some meaning. At least a party must have presence in at least 1/3 of the states, if not half of the states. If you have few national parties, then the voter will focus the attention when the Lok Sabha election comes on the national parties first before going to other thing. One other thing I wanted to mention is this, that there is a tendency of political dynasties coming into existence, family to family, passing on. We are suffering from lack of good governance. If the dynastic politics take over, what will continue is the same kind of misgovernance. There is a danger to the society, to the country. How to save the country from this? And lastly, as Vajpayee pointed out, everyone who enters politics aims at a ministership. And what kind of politics these days? Initially, political parties had some ideology. Now you find there is only one common ideology: to grab power by means foul or fair and retain it as much as you want, by all possible means. Coalition governments have given rise to unlimited corruption, horse trading, and you find many undeserving persons holding the highest position of decision making at the political level, the minister's position. So I think time has come to separate, for greater separation of executive and legislative wings of the state. Put some kind of qualified restraint. Don't allow any member of parliament or state legislature to hold an executive post except ministership. So that's necessary, collective responsibility to the parliament, etc. Then the cabinet form of government, whatever for. But even for them, lay down some conditions of eligibility. In fact, our Palkiwala, this I conclude, he said the grim irony of the situation where the one job for which you need no training or qualification whatsoever is the job of legislating for and governing the largest democracy on earth. You need years of training to attend to a boiler or to mind a machine, to supervise a shop floor or to build a bridge, to argue a case in law court or to operate upon a human body. But to steer the lives and destinies of more than 650 millions, now it's of course 1,000 millions, of your fellow men, you are not required to have any education or equipment at all. Friends, the silences of the Constitution are being exploited to the against the interests of the people of India. We need to do something. I'm happy that Mr. Jethamalani is here, not only an eminent lawyer, but also an eminent member of parliament, and who has been also minister. I would like him and other leaders of whose names I mentioned, please give us lead. Can we utilize the judiciary by invoking their powers in the manner I suggested, to ensure that the government considers the recommendations of the electoral reforms and satisfies the court. If they don't agree with any of them, why they don't agree? If they agree with some of them, why they should not be implemented. Thank you very much.
Thank you, Mr. Rao, for not merely giving a very elaborate list of the kind of electoral reforms which are needed, but carrying forward the session of Solicitor G also, of the action plan which really is going to matter the most. Now may I request Prashant Kumar.
Mr. Chairperson, distinguished panelists and members of the audience, it's my privilege to be here, to be speaking in front of you. I'm the odd person out. I don't belong to the legal fraternity, but nonetheless, I'll try and make some suggestions. But I'd like to suggest that before I can make any suggestions, we must understand the problem. We're like the 7 blind men and the elephant. Each one touches a different part of the elephant and thinks it's something else. Somebody touches the legs and thinks it's a pillar of a building. Somebody touches the tail of the elephant and thinks it's a broom. So the solution is either you have to solve the problem of the building or the broom. We have to understand the elephant as an elephant. So if we are from the legal fraternity, we will think of legal solutions. If we are from the NGOs, we'll think of an NGO-like solution, etc. But we must understand the problem in its totality. And let me try and spell out the way I see the problem and then come to the solution. This presentation here is based on my book, which Penguin had brought out in 1999, The Black Economy in India, and the second edition came out in 2002 with Mr. V.P. Singh's foreword, because he liked the book very much. We must understand the nature of the black economy before we can actually resolve it. And to do that, we must understand what is its size, how is it defined, and how it implies illegality of various kinds. Let me give you some data. Professor Caldor from Cambridge came in 1955 and he suggested that the black economy was 4 to 5% of GDP. After that, the Vanchu Committee in 1970 suggested it had increased to 7% of GDP. Then the NIPFP, which did its report in 1985, suggested that for 80-81, it had become 18 to